Hello and welcome to Module 4 of the Wyatt Special Education Advocacy Training. My name is Evan Farrar and I will be presenting this webinar on effective advocacy, which is a very important issue for not only parents but also school professionals as well. So I want to begin this webinar with sharing a really important quote, which comes from a great book called Getting to Yes. This is a book that I really encourage you to read if you haven't. It's all about negotiation and how to create a successful negotiating environment and relationship. And the IEP process is in many ways a negotiation. It's sort of designed that way for two parties to determine what is a common program that they will design for a student with a disability. So I hope that this quote will help you in framing what we're going to talk about in the rest of this webinar, and something that you can keep in mind as you hear some of the tips and strategies that I'll be sharing. So this quote says, "The challenge is not to eliminate conflict, but to transform it. It is to change the way we deal with our differences, from destructive adversarial battling to hard-headed, side-by-side problem solving." So I want to begin with some reminders, and these are things that you may already know or that you have covered in some of the other modules in this training, but these are always really important building blocks for understanding the special education process as well as the advocacy process. So the Individuals with Disabilities Act, which I will call the IDEA in this webinar, is designed to further education, employment, and independent living. The IDEA is the law that really creates the framework for special education. The IDEA is also designed to encourage a least restrictive environment, also known as the LRE, for each student with a disability. And this basically means that every student with a disability should, whenever possible, be in a more inclusive environment. The IDEA is also designed to promote a school-parent partnership to determine how to identify and meet the educational needs of a student with a disability. So the IDEA includes provisions to protect the rights of students and parents, and also calls for meaningful parent participation in the process. And the key word in that sentence is meaningful, not just casual, but meaningful participation in the IEP process. The IDEA is designed to create a free and appropriate education, otherwise known as FAPE, for a student with a disability. This means that each educational plan should be appropriate for the student based on their disability, and we'll talk a little bit more about that throughout the webinar. The IDEA also requires that schools offer an individualized education plan, otherwise known as an IEP, for each student with a disability. This means no predetermination of a plan or services because one size does not fit all. It has to be individualized. So let's talk just briefly about the playing field, and this is the playing field where special education advocacy occurs, and I just want to point out some key things to think about as we talk about special education advocacy. So the IEP team drives the creation of a plan to create an appropriate educational environment for a student with a disability. So one of the helpful ways to think about this is to use a car metaphor and to talk about how what the IDEA provides is not the Cadillac of plans for a student with a disability, but rather the Chevy. So it is an appropriate vehicle for giving a student with a disability the supports and services that are needed, but it is not required to give the best possible services and plan. So this is often a big point of contention between schools and parent advocates, because the argument is about what is appropriate and what is not. And frequently that's where IEP teams find that they get into a lot of conflict, because the way the law was written, it created a lot of ambiguity around that particular issue of what appropriate means. The IDEA process also encourages collaboration between parents and the IEP team, but it also assumes disagreements might happen. And so when disagreements happen, the IDEA offers remedies to resolve conflict, including a due process hearing. The due process hearing is probably the remedy that most parents have heard about. And so I'm going to talk about that for just a few minutes in a little bit more detail. So this is what is important to know about due process hearings, or at least some of the things that are important to know about them. First of all, they really are the most expensive option because typically a due process hearing is going to involve both an attorney for a parent and also an attorney for the school. So right there, the cost of this particular remedy goes up. Another thing to remember about a due process hearing is the burden of proof is really on the parent. So the parent has to show that the school violated one of the mandates or more of the IDEA in order to prevail in a due process hearing. Due process hearings are also very stressful for both parents and school professionals. They also don't always benefit the child in the long run and also can diminish trust between parents and the IEP team. So you may win the victory, but in the long run, the child doesn't win. So research suggests that have looked at who wins in a due process hearing that approximately 65% of the time, the school wins outright. 25% of the time, a parent wins outright. And then 10% are split decisions. Now, it's important to remember that many outcomes of due process hearings are not made public. So having a really clear handle on who wins and who doesn't on a percentage basis is really hard to determine completely accurately. But this gives us some idea, kind of an understanding of how often it is difficult for parents to win a due process hearing. But they are used a lot, as are other remedies under the IDEA. And an example of that is in 2016, the American Association of School Administrators estimated that school districts in the country spend over $90 million per year in IDEA conflict resolution. So now I want to talk a little bit about another big piece of the burden of special education, and that is really the burden that is on special education teachers. So why am I talking about that in a parent advocacy training? Well, because parents want to have good special education teachers. And in order for us to encourage good special education teachers and to encourage the development of more really skilled special education teachers, we need to think about what their burden is and then how we might be able to be part of the process of lessening that burden. So I think these statistics are really telling. In 2015, the National Coalition on Personnel Shortages in Special Education and Related Services reported these numbers from across the United States. So 49 states reported that they have a shortage of special education teachers and also related services personnel. 12% of special education teachers leave the profession, and that's nearly double the rate of other teachers in school districts. 82% of special educators in the United States report themselves that there are not enough professionals to meet the needs of students with disabilities. And 51% of all school districts have difficulty recruiting highly qualified special education teachers. And for high poverty schools, this number rises to an astounding 91%. So, in short, why do special education teachers leave at such a high rate? Basically, there seem to be 4 reasons. One is the massive amounts of paperwork. So if you're a parent and you think about all the paperwork that you have as a parent in order to help your child at school, think about a teacher who might have a class of, let's say, 15 people or 10 students with disabilities. Well, then they have all of that paperwork that they're putting together, and there are lots of rules and regulations about paperwork in the school system for special education. Another factor is isolation and lack of administrative support. Oftentimes that comes from the top down, and teachers in the special education fields sort of feel like they are off fending for themselves in many cases. And then there's role ambiguity and less instructional time. So teachers become teachers because they want to help people learn. But if they're bogged down with paperwork and they're not really sure what their role is in the system, then that becomes a job that they are less likely to want to stay in. And then finally is an important one based on what we just talked about with due process hearings that are so stressful. There is a legitimate fear that special education teachers have of being involved in a due process hearing if something goes wrong with the student with a disability they are serving. Now let's just talk really quickly about the special education student population and where students with disabilities are educated. So 13% of the overall student population in the United States have a disability, a recognized disability of some kind. And that comes up to over 6.5 million students in the US school system. And of those, according to the Department of Education, 95% are educated in a public school setting. So this is why public schools for students with disabilities are so important, because the vast majority of students with disabilities are in a public school setting. And now we look at how are students doing with disabilities at school? What is their achievement rate? And so I put a chart up here that you can look at a little bit more in the PDF version of this presentation that you will get. But here, just really quickly, you can see many of the gaps that there are. So if you look at reading in the 8th grade, the students with disabilities are below a basic level, 63%, versus students without a disability at 19%. And as you look at this chart, you'll see those kind of gaps pretty much throughout the chart. The only difference being, if you look at the reading in 4th grade, actually students with disabilities are struggling there as well, but there are some differences in the math area. If you look at students with disabilities seem to be doing well in that area or better. So how to look at that chart overall, the folks who created that study then report in 2015 that the performance of students with disabilities showed little, if any, improvement over the last 3 presidential administrations. And achievement gaps between students with disabilities and those without disabilities continue to be substantial. The majority of students with disabilities performed in the below basic achievement level in all areas except 4th grade math. So if you put all of this together, what does it mean for special education advocacy? Well, what it means is that effective special advocacy is absolutely crucial. It's crucial because good advocacy can make the IEP process work better. It can reduce the stress on parents and professionals. It can avoid costly due process hearings when possible. And most importantly, you put all of this together with effective advocacy, then it helps to improve educational outcomes of students with disabilities, which is really what the IDEA is all about. So for the rest of this webinar, I want to give you some really practical tools that I hope will help you as an advocate. So for some of you, you may just be starting out as an advocate for your child in a school setting. And if that's the case, I hope this will give you a really good place to start with lots of tools and strategies. If you're a more seasoned advocate for your child, then that's great. And then what I hope for you is that you will find some strategies and tools that maybe you haven't thought of or maybe you haven't used that might help you in the advocacy and the skilled advocacy you're already doing. So let's start with the fact that anger in difficult school situations is understandable and it's appropriate in many circumstances, but it is not a strategy. So you know, just in your own life, if you react out of just being angry in the heat of the moment, oftentimes that doesn't result in the greatest outcome. So it's important when you do feel anger and frustrated with what's going on at the school to sort of step back and give yourself a little bit of time to calm down and to identify more with the rational part of your mind and be able to craft a strategy that will address the very issues that might have made you angry in the first place. And that'll be usually a more effective process. You also want to document everything. You can never document too much. The thing about that is if you document and you do have to go to, for example, a due process hearing, you'll already be well prepared because you have all the documentation on your side of what's happened. Remember with an IEP that if it is not written in the IEP, then it didn't happen. So if there's something you want in that IEP, you want to make sure that it is written so that you're not just saying, oh, okay, we all agreed to this, but then you find out that the school says, well, we can't provide that service, and you don't have anything to hold the school accountable to without having it in the IEP. You want to always strive for a professional and respectful relationship with school professionals so that you are treating them with respect that they deserve as professionals, but you also want to expect the same from them. School professionals should also be treating you very respectfully because you're an important part of the process called for by the IDEA. In terms of special education law, I really think what you want to focus on is knowing the special education law that you need to know. Very few people are experts in special education law, and certainly among parents and advocates, that's the case. But good advocates know the law that they need to know. And oftentimes you only know that when you need to know it. So if an issue comes up that you're not sure about, you're not sure if the school is serving your child the way they should, it's really important then to look and see if you can find anything in the IDEA that might back up what you're saying. You also don't want to assume that school professionals always have an accurate understanding of special education law, especially on the front line. Even sometimes principals of a school don't really understand how they're supposed to be serving a student with a disability. So don't always just accept that word. You also want to check it. Doesn't mean that you think they're lying to you, but you just want to be aware that sometimes their knowledge base might be less than you think it is. So just always make sure that you're checking to see if what you think should be happening is what actually should be happening versus the school is telling you. Of course, the next one is a really important one, and that is be prepared for IEP meetings. Don't treat them like they are a casual event. Do the best you can to be ready to go when an IEP starts, and that's sort of what we'll be talking about in the rest of the webinar too. Be reasonable. Seems obvious, but it is difficult, especially if you get frustrated and angry with what's going on. But the standard of being reasonable is a really important one. And oftentimes, in my experience of talking to people who decide due process hearings, they will fall back in some ways on which side was more reasonable. You always want to be on the side of more reasonable. It doesn't mean you're not going to disagree, but it does mean you're going to do it in a way that is reasonable. Helps sometimes to bring someone with you to an IEP team. It's always like, 10 or 12 school professionals and 1 or 2 parents. If you're on your own as a parent, bring somebody with you, a friend, a sibling, anybody that will come there and just sit with you. They don't really have to do anything other than to be a support for you, and they can also listen and maybe give you a different perspective on what they're hearing. You also really want to understand academic testing and results. And that's important because it's the testing and those results that give you a performance baseline for your child. And if you don't know that baseline, you don't know where your child is starting, then you will have a tremendously difficult time knowing if they are actually making progress. So remember, in this sense, it really is all about the data. You want to make sure to pick your battles. Some things you can let go of, some things you can't. So if you put it in the context of Prader-Willi syndrome, one of the things you can't let go of is food security. That's a battle you need to fight. Others may not be as important, but when it comes to kind of the safety and welfare of your child, those are battles you need to pick. But if you look at some other things, you may be able to say, that one I'm not feeling like I really have to go to war on. And if you haven't done this already, definitely take some time to read the IDEA, and you can also check related commentary on how the IDEA is applied. And we'll have on the website, you'll see, for the training website, you'll see some resources that will help you do that. Especially with a condition like Prader-Willi syndrome, you want to translate medical language and issues into school language. And your medical provider should be able to help you with this. But you want to help the school understand how is that medical condition impacting their ability to succeed and be safe at school. Other key thing to remember is schools will not automatically follow what a doctor recommends. Sometimes parents think that, but school professionals sometimes will resist that. And you can sort of understand they don't really want somebody from another profession coming in to tell them how to do their job. So that's why it's important to prepare those letters in a way that is really tied to what it looks like for school. You know, in the playing field these days, you also want to really know what the difference is between a special education attorney and an advocate. So here are some of the differences. There are probably more, but these are the ones that I think about when I distinguish those two roles. So attorneys have a legally recognized confidential relationship with parents. That is a big difference. It means that what you say to your attorney is protected. That's a key. Another one is that attorneys can represent parents in due process hearings anywhere in the country. And the third one, as we talked about a little bit, is that attorneys, of course, are more expensive. Now, in terms of special education advocates, they are not licensed. So that's a really important thing to know. They also don't have a legally recognized confidential relationship with parents. So it's entirely possible that any communication between an advocate and a parent could be used, for example, in a due process hearing. Now, there may be some protections in certain states. I don't think there are, but there could be. So you want to check out in your state how they recognize advocates and what kind of rights and responsibilities they have. And that includes the fact that in many states, an advocate can't represent a parent at a due process hearing. It has to be by an attorney, but there are some states where an advocate can. The other very helpful feature is advocates are much less expensive. So having a really good advocate means that you can get the same thing done that you want to through a special education attorney, but you can do it at less cost. So especially in terms of advocacy or advocates, you want to really be careful to screen when you're hiring an advocate, because in many ways anybody can say they're a special education advocate, and because there's no licensing and process for that, a little bit like the Wild West with anybody can hang out their shingle as an advocate. So just screen those carefully, ask other parents if they've used somebody, you know, look at their resume, those kind of things, ask for references from other parents. All those things can help you screen an advocate. One interesting thing is, though, that in more and more situations, you can get the best of both worlds, in that you can find an advocate who works in an attorney's practice, so that you get the lower cost of an advocate, but you get the backup of an attorney available and involved with your case. So that's something you might want to look at too. Always affirm what the school does well. Saying thanks goes a long way. We know that in our own lives, and too often we focus on what's negative and don't remember to say thank you for what's positive. And with school professionals, that's really important. If an IEP meeting gets heated, and sometimes it will, remember you can always take a break or you can reschedule. You know, you can just say, time out, I need a break, I can't continue right now, and then just ask for a break or have it rescheduled, and that's totally fine to do. One suggestion I heard one time, I think it was through Wright's Law, that it helps to display a framed picture of your child at the IEP meeting. That just helps participants keep focused on what matters. Always good to have no surprises at the IEP meeting or with the school. So if there's something you want or that you're concerned about, give them a heads up and expect the same from them. Surprises don't help IEP team meetings at all. So that's part of being respectful both ways. Definitely keep your own IEP team minutes and share those after your meeting with the IEP team. And that can be by paper or by email. You want to include in those minutes items of disagreement as well as recommendations you have to resolve them. Also include items of agreement. Recommend you ask to see if those minutes can be actually attached to the documentation for the IEP team meeting. Sometimes schools will not do that depending on their regulations, but if that is not possible, you have your own email documentation of those minutes. Then when you go to your next meeting, you can go back over any areas of concern that have not been addressed. You want to focus, when you do have an issue that you're trying to resolve, a significant issue, on how that problem is really damaging your child, how it hurts them. State this clearly, verbally, and also in writing. But really focus on that issue of, this is how this is hurting my child to not have this issue resolved. You always want to be careful about the tone and content of your emails that you send to the school. Remember, all of those become things that could be used in a due process hearing. You also want to be very, very careful about what you write on social media. So if you have a bad IEP meeting, not a good idea to go and vent about that on Facebook. Find individuals to talk with that about, but don't blast it all out to everybody, because again, there is no confidentiality to what you are writing in a public setting like Facebook. Create a simple form you can present to the IEP team every year that covers strengths, challenges, and goals and objectives you have for your child. We actually have a download that you can do with this module of a great example of that to help you keep track of your records and prepare for IEP meetings. We sort of are talking about this, and that is, you want to protect your relationship with school professionals, keep the lines of communication open. There is nothing more important to the education of your child than having the best possible relationship you can with the school professionals. Be cautious about sharing too much personal information with the IEP team. You don't want to share what's relevant, what you think is appropriate, but you don't always want to share everything, because sometimes, for example, if you share something that's going on in your family at home, sometimes a school might be tempted to say, well, we're seeing problems at school because of what's going on with home. You want to make sure to help the school to stay focused on what's happening at school. You want to try not to make negative assumptions about school professionals. Most really do want to serve your child well, the vast majority. So just keep that in mind. Give them the benefit of the doubt until you have some reason not to do that. This is a big one. Be cautious about accepting school advice from other parents. They may mean well, and in most cases do, but what works for one child doesn't always work for the other. And so every situation, because it's different, is probably going to have a different outcome and a different set of interventions that help. So just be very careful about, if a parent says, hey, I did this, this is what you should do for your child. Just be cautious about that. It's important to understand those mandates we talked about earlier under IDEA to prepare students for further education, employment, and independent living, because those have a big impact on how the school looks at what they're doing for your student. You want to encourage the IEP team to begin every meeting with a positive about your child from each participant. Every child has strengths, and you want to start with that. Make sure somebody says each person a strength that they feel your child has. Oftentimes when I look at an IEP, I can quickly tell if a school likes a child or not because of the language they use to describe the child. Encourage your IEP team to be strength-based in how they evaluate your child's participation at school. Now, this one is an important one. It's a hard one, but work to understand the school perspective. It is absolutely essential for creating an effective advocacy strategy. If you know how they're looking at it, it'll help you to craft a strategy that will help address some of those concerns. So I just want to give you 3 quick examples of that. So if there's a behavioral incident at school, and let's say a student was sent home for the day, before the student can come back to school, well, the school is looking at it primarily as safety. If there was an aggressive incident, they want to make sure that other students and their staff are safe. Parents going to look at it like, I want to get my child back into school. Of course, we want to address and make sure everybody is safe, including my child, but I really want to get them back in school. So if you can look and bridge those 2 perspectives, then it's much easier to create a resolution by the IEP team. So another example would be a paraprofessional wanting a one-to-one aid for a child. Parent really wants it. They believe it'll help their child in the educational process to be more successful. However, because of those mandates with the IDEA, the school looks at it and says, well, we don't want to make your child's environment more restrictive. We want to keep them as included as much as we can. So again, two different perspectives. If you can look at the other perspective by the school, you can figure out how do you bridge that gap creatively. Final one is the life skills class. So with Prader-Willi syndrome, those are always challenging class situations because usually it involves some sort of food activity or food-related activity. So the parent is thinking, I don't really want my student in the life skills class in the same way as another student might be. School, because of the IDEA mandates, are looking at it saying, but we have to prepare your child for employment and independent living in the future. So again, those two perspectives, if you can understand them, it creates the ground for finding a good solution that bridges the gap. Always want to pay attention to transition planning as your child starts to get older. Schools often forget to do that or just don't do it very well. So just make sure you're asking that question at IEP meetings as your child gets older. And we're talking about, when they get in the probably 10 or 12-year-old range, you want to start just asking about that and just see where things are. You also want to seek out training. Remember, effective advocacy is a learned skill. You're not born with it. So you can find all kinds of training, and I've listed some possibilities there with books and webinars, and of course, this training that you're doing here with us through the Wyatt program. More tips and strategies. So you always want to educate school professionals about Prader-Willi syndrome. And when you do that, don't forget paraprofessionals, school nurses, phys ed teachers, substitutes, bus drivers, pretty much everybody that's going to be in some way serving your child. You want them to have an understanding of Prader-Willi syndrome. It's also important to visit and share information with the new school placement in advance. And one of the things I like to encourage parents to do is put in the IEP that staff are required to have a yearly training on Prader-Willi. That way, you can make sure that people look at materials and read materials that will help them to understand how to serve your student better. And remember, if it's in the IEP, then it's more likely to get done, and you can go back and hold them accountable to that. What happens when you disagree with an IEP team decision? Well, first of all, you ask for an explanation of their decision, and preferably you get that in writing. You just ask and say, can you help me understand why you all think this is the best route to go? Then you want to listen to what they propose, and if it's reasonable, try it. Why not? You may find out that it works. But put a time label on how long you will try that out. Set a date for the IEP team to meet again, and don't make it too far off so that you can meet and say, okay, how's the plan working? And if you find out from your evaluation that that plan is not working, then you ask for the plan you requested to be implemented, and you'll have a lot more leverage to do that. This is something parents often forget to do because you're handed so many papers by the school, but you want to make sure to read really carefully any information the school gives you about policies and procedures in your school district. You don't want to have to figure out what a policy is on the fly when a crisis happens. You want to have some awareness at the beginning, and so don't take lightly that information they give you. Remember what we talked about with meaningful participation by parents in the IEP process? That's one of the ways your participation can be meaningful, by reading that information and being knowledgeable about what your rights and what the procedures are in your school district. You want to do the same thing for the special education system in your state. That is really important. Another area people forget to look at, but for states that have special education departments, you want to make sure that you're looking at what their resources and what their policies and procedures are. Now, here are some questions that me and my colleagues here at Prader-Willi Syndrome Association often get when we work with families on school issues. So one is about taping an IEP meeting. Can you tape an IEP meeting? So the answer to that is it depends. You need to check to make sure taping a meeting is legal in your state. So you never want to record a meeting without finding that out, because that can be a crime. So check that first, find out if you can record and what the criteria is for that. I always think you should inform the IEP team you are recording and why. I would want to know that if somebody was going to record me, and I think that's just part of being respectful. And then I think you also want to consider the pros and cons of taping. I can see when parents want to record, and I can understand those reasons. But there are times where if you do decide to tape a meeting, that is going to reduce the openness and probably creativity of the IEP team to problem solve. I think where it is really helpful is if you just have trouble retaining all the information that's talked about, and if you present it that way, then I think schools are much more receptive to it. But think through all of these things before you end up taping, if you decide to. We also get the question a lot about, what about signing an IEP? Do I have to sign an IEP? Again, it depends. That varies around the country. So you really need to check the policies and procedures of your state, because it can be completely different from one state to another. So the answer to that is it depends. Check your state. Some people also ask for a draft of an IEP before the IEP meeting to determine the IEP for the next year. Well, some districts allow a draft to be prepared and allow it to be shared prior to a meeting. So again, you have to check with your school to find out what their policy is on that. Many do not allow that, though, and here are some reasons why. One is because it could exclude meaningful parent participation, meaning that if the school is without the parent sitting down, deciding what the IEP might look like and making recommendations, then it could be that the parent is really more just like a rubber stamp and not really meaningfully participating in the creation of that IEP. The other issue is that a pre-prepared draft might also appear to predetermine supports and services for a student with a disability. So again, coming back to that individualized education plan that's required, part of that means that you want to be careful about predetermining services for a student with a disability. I also really encourage parents to allow school professionals to do their jobs and to really encourage them to do that. So just a quick example, behavioral management. I don't know how many folks out there who have a child with Prader-Willi syndrome who have been or are part of the behavioral management at school for their child. An example of that would be they get called to the school when their child has a behavioral problem to help resolve it. That's what school professionals should be doing, not you as a parent. So that's what I'm talking about. You want to allow the school professionals to develop that relationship with your child in the school setting and have a good plan that you can help them develop to meet the needs that they have. Part of being a good advocate is asking questions if you don't understand something that the school's proposing. Good example of that would be goals and objectives. Lots of parents who call and ask me, what do these goals and objectives mean? Or what should I come up with for goals and objectives? Again, the school needs to come up with those goals and objectives with your input. And you always want to understand things. So if you don't understand something, you just use that question. Hey, I don't understand this. Can you help me figure out what this means? That is such a good way to approach it. You can often ask a question that gets the information that you want in a much more effective way than if you do it in kind of a declaratory statement to a person about what you think they mean. So keep asking those questions. Effective advocacy, remember, is not just about getting things done. It is also about getting things done in a way that strengthens your relationship with school professionals. This is what creates an environment for sustainable collaborative problem solving. So it's kind of like you don't want the slash and burn method if you can avoid it. There are certainly situations where people are effective getting supports and services by going into an IEP meeting and just being very aggressive and in conflict with the school professionals. But over the long run, that is not really good for the collaborative relationship. I don't even think it's good for the parent, certainly not also good for school professionals. And ultimately, the goal is to make everything good for your child. And so the more collaborative you can be with the IEP team, the better the relationship, the more likely it is that the environment that's created is going to be better for your child. So just keep that in mind. As you can probably tell, I'm a big believer in positive interaction and collaborative problem solving. It's definitely my bias. But if you are somebody that feels a more aggressive approach works, that's fine. But I just want to ask everyone listening to sort of think about that. And, going back to that quote we had at the beginning of the webinar, how can we be effective negotiators that really help us to be kind of hard-headed problem solvers together, where conflict's not denied, but it's used as a way to problem solve. One thing is that you feel that your relationship with the IEP team is on the wrong track, then hit the reset button. You can do this anytime. And I say this to school professionals as well. There's no reason why the IEP team can't get together and say, how do we make our relationship better? What things can we do to remove the mistrust that we have going on? How can we communicate differently? I mean, it's a team, and it's designed to be a team to work together. And because conflict is probably going to be part of that team no matter what, if you find that you're getting bogged down in it, then you take the part as the parent to see if you can hit the reset button and try to get things back on track. We are always happy to help with that here at Prader-Willi Syndrome Associates. A big part of what we do is being a bridge between parents and IEP teams that might be struggling with how to problem solve an issue. So last but not least, and I really mean that, is this tip, and that is to take care of yourself. It is absolutely true that good self-care is a major key to being an advocate. Without it, you'll probably burn out. And when you're burned out, it's easier to get angry. It's easier to get frustrated. It's harder to think clearly. It's harder to have patience, more easily get irritated, all of those things that make it difficult for you to take on this very challenging role of being an advocate for your child in a school setting. And that's the other piece of it. Just as we've talked about in this webinar, and if you listen to the other 5 webinars that we have in this training, there's a lot expected of parents. There's a lot of stress involved in it, even if you have the best IEP team relationship. So with that kind of burden, you have to really make sure that you're looking at the issue of how to take care of yourself throughout your child's school years. So here are just some ideas for how to practice good self-care as an advocate for your child. So one is to schedule time for yourself on a regular basis. And that means schedule it. Put it in your weekly schedule. Put it in your calendar on your cell phone. Make sure that you keep that date with yourself to take care of yourself. And make sure you ask family and friends to help you with this. That could be a spouse, partner, family friend, a relative, but somebody that you can say, hey, can you help me to make sure that on a regular basis I can keep this appointment with myself to practice self-care? And that might mean they help take care of your child. They might take care of some other responsibilities you have at home, but really use that as a way to lean on your support system to have them help you with this important task. And then you can explore self-care activities. I've only put a couple of here, and self-care activities will vary from person to person, but certainly exercising can be a helpful process with reducing stress and keeping you healthy. Maybe getting a night out with friends where you can just go have fun and sort of do what you want without the stress of being at home and worrying about what's going on with your child. And lots of people have found great relief and techniques such as meditating that help you to kind of center and quiet yourself and find a place where you can recharge and renew your energy. Also important to find supportive communities and people who can walk with you on the journey. This doesn't mean it has to be a community of just people who have children with disabilities. That can certainly be one source, but you may find other communities. You may just want to break from folks who are raising a child with a disability and would just like to find some folks who you talk to about other things. Also, of course, includes religious communities, other community groups that you might be part of or can find. The key is don't stay isolated. Make sure that you're connecting with other people as much as you possibly can, because isolation definitely leads to stress, and you want to avoid that as much as possible. So seek out those folks. And then finally, if you find that you're really struggling, you've tried some of these other things, or you just can't get them started, in my opinion, don't hesitate at all to reach out for professional help. It's a smart thing to do. It'll help you to be a better advocate if you're really struggling to get back the balance in your life and be ready to do all the things that you need to do as a special education advocate for your child. So some next steps that we have for you after this webinar. We have some great free resources for each training module. They're available for download from what will be the training website for this training. If you need assistance with the school issue, you can always contact us at the Prader-Willi Syndrome Association. Our number is there. Just ask to speak to a family support counselor. We'd be happy to talk with you about what's going on at school and how we can help. If you do have questions or comments about this module or our training in general, we'd love to hear them. You can send them right to me at efarrar@pwsausa.org, and love to have your feedback. And so this concludes this training webinar. I thank you very much for attending. We're delighted that you are looking for more training and hope that the information that was shared in this webinar will be useful to you and helpful to your child. Thank you very much.